Number 67, John W. Terry et al., Petitioners versus Ohio. Mr. Stokes.
Mr. Chief Justice, may it please the court. State versus Terry comes to this court by virtue of a writ of certiorari granted to the Ohio State Supreme Court. This case originally arose in the Common Pleas Court, Cuyahoga County, based upon an indictment for carrying a concealed weapon, in violation of Ohio Revised Code Section 2923.01. The defendant in this case filed a motion to suppress the evidence, and at the trial there was a hearing on the motion. After hearing, the motion was overruled, and the case proceeded to trial. This was a bench trial, jury having been weighed. After hearing the evidence, the motion originally filed was overruled again. The defendant was convicted of carrying a concealed weapon. The trial court wrote an opinion in this case. We then appealed to the Court of Appeals for Cuyahoga County. This court sustained and affirmed the conviction of the lower court. This court also wrote an opinion. Subsequently, application was made to the Ohio State Supreme Court for review. That court dismissed the application for review, stating no debatable constitutional question. This court granted certiorari. The facts in this case are these, and I think they are signally important if we are to try and arrive at the proper verdict with reference to this case. This incident occurred at 2:30 in the afternoon in broad daylight in the downtown section of Cleveland, Ohio. The police officer in this case, one Martin McFadden, noticed two Negro males standing at the corner of 14th Street in the city of Cleveland, where Euclid Avenue and Huron Road intersect. These two streets, if the court please, form a triangle at the apex of East 14th Street. The police officer was approximately 100 feet away from where these two men were. He positioned himself...
What kind of a neighborhood is that generally in Cleveland? A business neighborhood?
That is our downtown section, the busiest section of the city, Your Honor.
Downtown retail stores and offices and so on.
Yes, Your Honor. And the testimony of the police officer was that there was business as usual in the downtown center of the city. Stores were open. There were pedestrians on the street.
What time of day was it?
2:30 in the afternoon.
On a weekday?
On a weekday. The police officers stated that he positioned himself in the doorway of a department store by the name of Rogoff's. For a period of 10 to 12 minutes, he observed these two males at the corner. Alternately, each made 5 or 6 trips over to two stores located on Huron Road. He said that he didn't know whether it was the United Airlines store or the Diamond store, but the stores were immediately adjacent to one another on Huron Road. During these 5 trips that they made during the 10 to 12 minute period, a third male came by, white male who stood and talked with the two males there for a moment or so, and then the other male proceeded west on Euclid Avenue, and the two males continued on this corner. After the 10 to 12 minute period, the two men then walked west on Euclid Avenue, some several hundred feet down Euclid Avenue. When they arrived at Zucker's store, which is in the vicinity of 9th Street or 11th Street there on Euclid Avenue, the three males then again met up, at which time the three of them, according to the police officer's testimony, were merely standing in front of Zucker's store.
What kind of a store is Zucker's store?
Zucker's is a haberdashery, Your Honor. His testimony was that their backs were to the plate glass windows. They were facing the street. And when interrogated with reference to what they were doing, he said they were merely standing there talking. He described their gait away from 14th Street as they walked down to the haberdashery as a normal walk, nothing unusual about it. The police officer then says, I then went over to the three men. I said to them, I'm a police officer. What are your names? In the first instance, he said, they gave it to me quick. In all other places in the record, he says, they mumbled something. He said, at this, I then reached and got Terry. I spun him around, holding him in front of me. I then began to pat him down. Once he had patted this man down, he says, I felt inside of his top coat what felt to be the handle of a gun. I then reached inside the coat and tried to remove the gun. I could not remove the gun. I therefore took the entire coat off of him and then took the gun out of the coat. At this point, he says, I ordered the three of them into the store. As I walked through the doorway, I said to the store personnel, order the wagon. He later explained that ordering the wagon means you are then under arrest. Once inside the store, the three men were ordered up against the wall, whereupon he then searched Chilton. Inside of Chilton's top coat, he also found a loaded revolver. He searched the third male Katz, upon whom he found nothing. He then caused these men to be removed from the haberdashery to Cleveland's police station. When they arrived at the police station, they were then booked for investigation. Sometime late the next day, after having been interrogated the following morning, these men were then charged officially, late the second day, with carrying concealed weapons. The police officer testified further with reference to questions propounded to him having to bear on the question of probable cause. We asked him, did you know any of these men? No. Had you ever seen any of these men previously? No. Had anyone given you any information regarding them? No. He was then asked what had attracted his attention to them. He said, well, to tell you the truth, I didn't like them. And I was attracted to their actions up there at 14th Street.
He said, what? I didn't like.
In the record,
What was your answer?
he said, well, to tell you the truth, I didn't like them.
Didn't like them.
Yes. And then he said further, Mr. Justice, that I was attracted to their actions there at 14th Street. This officer testified further, though, that he felt that they might be casing the place for a stick-up. The court then inquired of him specifically if he had ever, and by the way, this police officer had been a police officer for 39 years and a detective for 35 years. He was in plain clothes, Your Honor. The court specifically asked him if he had, during his 39 years as a police officer, ever previously observed anyone casing a place. He said no, he had not. Asked if he had ever arrested anyone for casing a place. In his 39 years, he said that he had not. We should like to make reference just briefly to the decision of the lower court in this matter, where our court held in that opinion that there is no evidence that any warrant had been issued for a search or frisk, and I'm not going to stretch the facts and say that there was a lawful arrest prior to the frisk of the defendants. I believe it would be stretching the facts beyond reasonable comprehension and foolhardy to say there was a lawful arrest, because there wasn't from the facts as presented. Later in the same opinion, our trial court said, I believe, and I reiterate again, that search and seizure law cannot be applied to this particular situation, although Mr. Reuben Payne endeavored to show there was a lawful arrest. But the court cannot agree. If there was an arrest, it came subsequent to the frisk. The court then based its decision upon Kerr versus California. The court said that the Kerr decision did not preclude the states from developing workable rules in order to bring about effective law enforcement in the states. The court said, with reference to the acquisition of the gun, that the gun was the fruit of the frisk, and that probable cause arose once the police officer had frisked, found the gun, he then had the probable cause to arrest. Our Court of Appeals, in affirming the decision, stated that a policeman may, under appropriate circumstances, reasonably inquire of a person concerning his suspicious on-the-street behavior in the absence of reasonable grounds to arrest. Our court admitted that in all probability this will lead to abuses by the police, but then went on to say that the court would deal with the abuses as they arose before the court. The court stated further that this, of course, was just a minor inconvenience with the personal liberty that is guaranteed, and that therefore each citizen ought to be willing to give up this amount of his personal liberty in order that they might have effective law enforcement in the community. Our court offered this definition of arrest, that as the term is used in criminal law, signifies the apprehension or detention of the person of another in order that he may be forthcoming to answer an alleged or supposed crime. They distinguished Henry versus U.S. by saying that in that case the government had made a concession, and therefore when this court rendered Henry, that it was rendering it on the unique situation where the government had come in and conceded that at the time the automobile was stopped, the arrest had occurred. And they therefore said this court had not in that case rendered an independent view of the facts, and in fact held that this was an arrest in the absence of probable cause.
I suppose your contention here is that policeman had, there's nothing in the record to indicate that the policeman had any reason to fear bodily harm to himself.
Well, we're saying that, and we're saying in addition to that, this, Your Honor. We're saying that at the point this police officer approached these men, and at the point that he lay his hands on the citizen, that he did not have the probable cause that is required. He had stated that all he had at that point was this intuitive sixth sense, and that he had never in his long experience as police officer ever arrested anyone for this purpose.
Well, I understand that, but we have to think about your case and the preceding cases in whatever relationship may be appropriate one to the other. And here there is no suggestion, is there, that the policeman had any basis for fear as to his own safety? Am I right that there's nothing in the record that indicates
there's
that?
nothing in the record whatsoever. And we might have...
And what happened here, and perhaps it would be your contention that policeman was engaged in a search for evidence when he spun Terry around and put his hand inside of his coat. Is that your position?
This is our position, Mr. Justice Fortas.
I don't understand your answer to Justice Fortas when you said there's nothing in the record to indicate that the policeman didn't have concern for his own personal safety, because I thought he said that based on his intuition, he thought these people were casing a place in order to rob it. Isn't that what he said?
This is what he said.
Well, presumably then they would be armed, and the minute he walked up and talked to them, he would quite reasonably be concerned for his own personal safety, I should think.
Well, if I understood Mr. Justice Fortas' question correctly, I understood him to say, was there anything in the record which indicated he had any reason to be concerned with his own personal safety.
Well, this much is in the record, that he thought, whether with or without reasonable cause, he thought or suspected that these were armed robbers about ready to hold up a place. And I suppose if you walk up to such people and begin asking them embarrassing questions, you might have some little concern for your safety if you bona fide believe that they have weapons on them. Now, that much is in the record, isn't it?
Yes, sir.
No, is that so? Excuse me. But is that so? Does the record show that he thought these men were armed before he put his hands on them?
Yes, he says, after he says that he thought they might be casing the place, and I felt that they might have guns. He did.
He said he testified to that effect.
Yes, he did. But in both our lower court and in our appellate court, in stating that a police officer should inquire promptly into suspicious on-the-street activity, we brought out the fact, and the record will show that there was no interrogation, there was no investigation in this case as a result of the officer approaching. Now, the court has said that he had the right to approach, to investigate, and to interrogate. But the only question in the record is, what are your names? At which point he then grabbed Terry, spun him around, and begun his search. During the interim period, while they were waiting for the other police to arrive, there was no conversation between the police officers.
But Mr. Stokes, do you think really, if there is enough to suggest that he had reason to believe they had weapons? If that's so, and if he's justified for that reason in asking them what they were doing, don't you think he'd be justified in the first instance in confirming whether or not they did have weapons before he went on further to interrogate them? Or even to interrogate them at all?
Well, if I understand your question properly, Mr. Justice, you do preface it by saying if there is enough.
That's right.
And
yes, this colloquy you, Mr. Justice Fortas and Mr. Stewart, would have, on the premise that it was reasonable for him to think that they had weapons.
Well, if there was enough, if the constitutional criteria had been met, I would say yes. I have no quarrel with the fact that where one makes a valid arrest.
Well, do you quarrel with the fact that, or do you suggest there had to be more than appeared before he could ask them a question?
No, I say if he wanted to, I had a right to ask him a question.
Well, now, if he had the right to ask them a question, we'd have lay that aside from him. And he also had reason to think they might have weapons on them. Would he have to question before he frisked them for weapons?
Well, if we are to say first that he has a right to question, I'm saying that he can exercise a discretion if he chooses. I'm not saying that at that point he has an absolute right to question them.
No, but would he, in your view, be abusing any right of the three of them in walking up to them and asking their names and what they were doing there?
Yes, I am.
Oh, you are?
I'm saying that where a citizen is on the streets and where all of the criteria that we know of by way of the development of probable cause is absent in a situation.
That then the officer has no right to stop and ask, what's your name and what are you doing here? Is that it?
Well, if we're going to use the absolute term, no right, and we're to be held to that, then I would just have to say he has no right. It seems to me that if he wants to exercise some discretion on his part of walking up and posing a question, asking a name, asking an address, this is a right he has. By the same token, the person whose liberty is being invaded, the person who has committed no overt wrong, and the person who is only suspect at that point.
Well, maybe we try to get at it this way, Winston. Up to the point where he spun Terry around, had he done anything outside what a policeman might properly do?
No, he had done nothing outside of what a policeman might ordinarily do.
Now, if then at that juncture he had reason to believe they might be armed, Did he have to complete his questioning first, or could he frisk them?
I would say under the circumstances presented to me that he did not, under those circumstances, have the right to lay hands on the citizen.
And this would be because you do not think the record shows that he had any reason to believe they had weapons?
No, that he didn't have. I'm saying that the point that you lay your hands on the citizen and you begin to exercise dominion over that citizen on the streets by spinning him around. I'm saying in order for you to do this, that you must have the probable cause that is required to place a person under arrest, because this person is substantially under your custody, your dominion.
Then you mean he can't frisk for weapons without probable cause to arrest? Is that what you're saying?
Yes.
How long had you seen them there?
A period of 10 to 12 minutes, Your Honor. Seems to us, and of course our position is in this case, that the MAP exclusionary rule under the Fourth Amendment would apply to this situation. We're not here advocating any change with reference to the Fourth Amendment. It seems to us that the state is in the position of saying to the court that they are not satisfied with the MAP exclusionary rule. As we read the rule, as we read MAP, we don't see where the court carved out any exception with relation to a gun. It seems to us that the court said that any arrest based upon anything other than probable cause is an unreasonable arrest, and that all of the evidence must be excluded. We think that the deterrent that MAP affords with respect to illegal searches and seizures is something that we are willing to continue living with. And though Terry is before you, we think that it goes much further than this. We think that when the state is saying there's something called reasonably suspects, reasonable suspicion, as it is put in some jurisdictions, and they're asking this court to relax the Fourth Amendment as it is known. They're in effect asking this court to nullify the Fourth Amendment and to overrule MAP versus Ohio. We think, therefore, that if this is to prevail, that it is for the state to be able to persuade this court that this court has somewhere in history permitted something other than probable cause to determine whether an arrest, a search, and a seizure is probable or one that is impermissible. Some of the jurisdictions.
Folks, I wonder if that has to be broken down a little. I wonder what you would say to this. Of course, a police officer does have the right to investigate a crime. And this police officer in this instance had the right to investigate crime. He did see what one might well say were suspicious acts on the part of people whom he thought might be preparing to commit a crime. He had a right, did he not, to pursue that farther, to determine whether or not he would have probable cause, perhaps for an arrest. Pursuant to that, he went to talk to these men. Now, because of the nature of the crime, that he suspected a robbery, he felt that when he went into the company of these three men against himself alone, that he was in a dangerous position, and that therefore he had probable cause to see if they had weapons on, not because he had probable cause to believe they had committed the crime, but because in investigating the matter, he had probable cause to believe that his life was in danger. Under those circumstances, would you think that he did or did not have a right to ascertain whether he was in a position of danger by seeing if they had weapons?
Well, only if we're going to relax the standard of probable cause as we know it under the Fourth Amendment. He didn't permit the situation to ripen into the point where it had ripened into a probable cause type of a situation. He was a little ahead of himself in this situation. And our position would have to be that you don't have a right to protect a constitutionally impermissible arrest. And so consequently, this is the way we would have to answer the vote.
Well, police officers are very often in position where they might not be able to make an actual arrest, but they are in a position of great danger. And where they are in a position of great danger, are they in a position to protect themselves from violence by looking into the situation to see if anyone is armed to do the violence?
Yes, Mr. Chief Justice, he certainly has a right of self-defense, and he has a right to protect himself. But the product, once it has been removed, the danger has been removed. And we're saying that in this case, since it was not based upon probable cause, we should not protect the constitutionally impermissible arrest by permitting the yield of that arrest to come into evidence against the defendant.
Take a situation of this kind where a police officer sees someone acting very peculiar. Might not be in connection with any information he has about any crime. Maybe the person is abnormal mentally. Maybe he thinks he's insane, and he wants to talk to him, but the man shows indications of what he thinks of violence, and he wants to be sure that he won't be attacked when he goes to talk to him. And he goes up to speak to him, and also ascertains whether he has any weapon on him. Did you think he had a right to do that? As a matter of probable cause that he might be injured himself if he doesn't take precautions.
Well, I think we're faced with this, and trying to reply to your question. I think we're faced with this, Mr. Chief Justice, that the average police officer would do this under these circumstances. If he felt himself to be in any type of danger, that he would conduct a search for the purpose of protecting his own life in a possibly dangerous situation. But I'm saying that we cannot, merely because of that type of situation, and it not being what is required under the Fourth Amendment, we can't give sanctity to it by way of saying, since you did find this product, we're going to permit it into the evidence.
No, I'm not arguing with you. I'm just saying how far we have to go in a situation of this kind. That's the only reason for my question.
Certainly. Another reason we think that the court, another thing I think the court has to take into consideration here, of course, is the impossibility that this court has of standardizing such a subjective thing as intuition. All of the amicus briefs say, permit us the standard that is less than probable cause. Permit us to stop and frisk people on the streets. Now, experience has already taught us, if the court please, that policemen have had enough difficulty being able to grapple with and to determine for themselves what is tantamount to probable cause, as it has been enunciated in decisions by this court. Now they're saying to this court, give us another standard, give us this reasonably suspects, or based upon suspicion, whatever the standard is less than probable cause. And we think that we're just compounding the policeman's problem if the court does permit this type of a thing to occur. With reference to the basic guarantee that we're concerned about here, I don't think we're so much concerned really about Terry, because over the years, it has been the person who has been involved in criminal activity that has come before this court in order for this court to again take a look at are some of our basic constitutional guarantees. And I think through Terry that we look at the hundreds of people walking the street by the day, because a police officer finds himself observing a situation where he says, as he did in this case, well, to tell you the truth, I just didn't like them, and then I began watching them. And then the fact that he wants to go further. And at that point, I think we're subjecting all of the people who have this inviolate right of privacy to this type of activity on the public streets throughout our nation. I'd like to reserve 5 minutes of my time.
Mr. Payne?
Mr. Chief Justice, if it please the members of the court, at the signal outset, may I direct my attention to page 19 of my brief. And there it is indicated that after the officer had testified that he observed the conduct of these men and that he had concluded that they were casing an establishment for a robbery, we find this quote appearing from the record. Question, Detective McFadden, can you tell us why you turned John Terry around, facing the other two men with you behind him? Answer, due to my observations, the observation on Huron Road of these two men, I felt as though they were going to pull a stick up and they may have a gun. That is supported and substantiated in the record of this particular case. A question has been asked here. What is the difference between reasonable suspicion and probable cause? In one instance, in the arguments of the case before this court, the Court of Appeals in the Peters case has said, it is that cause which is somewhat below probable cause on the scale of absolute knowledge of criminal activity.
The question I had in mind was this. I can understand why you can have a difference in wording. That says scale, a little below. I can't myself see any difference in fact. I'm talking about concept. In having a reasonable suspicion that has been done, and having a probable cause to believe in something.
I cannot see any basic difference in having a reasonable suspicion and equating it with the term probable cause in of itself. It has been indicated that we have asked for a different standard here as to probable cause. I find no problem with this particularly because I do not ask for a different standard of probable cause as it may relate to the right to lawfully arrest a person. I think that the quantum of evidence that is basic and essential under the circumstances to establish probable cause for the officer to arrest, for to stop a person and to ask him questions may be somewhat lesser in degree, but by the same token, it is probable cause under any circumstances. The same circumstances are indicated.
What do you understand probable cause to mean that a thing may happen?
I understand probable cause to mean for an arrest.
Or anything, probable cause to believe that something will happen. What do you say after you say that?
When a person is observed in circumstances which suggest that he has committed or is about to commit a felony or a misdemeanor, and such action is reasonably necessary to enable the officer to determine the lawfulness of the person's conduct, And the key word here is the circumstances at that particular time.
Now, would you mind telling me in your language, plain everyday language, what you understand to be meant when somebody says, for that reason?
For this,
says that the thing is probable cause to believe that something will happen.
I understand that to mean taking into consideration the totality of the circumstances as the responsible person views it at that particular time in relation to his work. For example, the police officer here, taking into totality the circumstances as that he observes under the conditions which he observes them, that the conduct that existed, the idea that may be flow from the conduct which he has observed here would establish probable
Do
cause.
you understand that it means reasonable ground to believe something's going to happen?
I understand, I believe that it does mean reasonable grounds that something is going to happen.
Does it? It is bound to happen.
It does not mean that it is bound to happen.
Therefore, you've got to have something to mean it's reasonable ground, so say you believe it happens.
I agree with this.
Well, Mr. Payne, in this case, this arresting officer testified, did he not, that he had never seen anybody case a joint.
That is correct. He did so
He
testify.
also testified that he'd been on that same area for some 30 years doing the following things: checking for pickpockets and shoplifters.
That is correct.
So where did he get his expertise about somebody's about to commit a robbery?
I think that he would get his expertise by virtue of the fact that he had been a member of the police department for 40 years. And by being a member of the police department for 40 years, I'm quite sure that even if by osmosis, some knowledge would have to come to him of the various degrees of crimes.
Now we get intuition by osmosis.
Not at all, sir.
I hope
Not at all. Not at all. I did not mean, I
I'm
didn't
sorry.
mean to imply that, nor did I mean any disrespect by so using that particular term. I think that, for example, if I, as a lawyer, am around a particular office for a number of years, then I certainly must gain knowledge about various concepts of law that may come about from time to time.
There are exceptions to that.
I would agree with the court in these circumstances also.
Well, seriously, Mr. Payne, the point is that the only thing he noticed was a man leave from position talking to another man and go across the street, look in the window, and go back.
I disagree.
Now, number one, you'll agree that everybody that looks in a public window is not casing a joint. You agree?
Agreed.
But they did do it twice or three times. How many times?
It was,
It's not too clear to me in the record.
right. May I then, in response to the justice's question, indicate, first of all, and clarify this. His testimony was not that he didn't like them. His testimony was that he didn't like their looks. Now, I don't think that he meant by that any reference to pigmentation or anything else. I think that he meant by that, when we take the entire record into consideration, the fact that this was in a downtown area, that these people were not continuing in the regular flow of commerce of other people that were on the street.
That they bad watching, you would say, wouldn't you say?
I'm sorry, I didn't.
They bad watching.
They bared watching.
Yeah.
They were standing on the corner conversing. Then, because of their not continuing in the flow of regular commerce, he observed one of the petitioners walk away from the other one and proceed approximately 100 feet west of the street. He noticed the unusual activity of this petitioner peering in the jewelry store or the airline office there. That was something in the vicinity of the airline office or the jewelry store which excited the petitioner's attention in some manner or in some way. He then returned to his companion on the corner, had a conversation with his companion. His companion, in turn, alternately proceeded up the street and conducted himself in the very same manner, that they alternated in this way 4 or 5 times, that thereupon a third man came from across the street and had a conversation with them. After having a conversation with them, that the third man returned back across the street and stationed himself there. That these individuals then engaged in the conduct which I have described previously, 4 or 5 additional trips after that. And then after engaging in these additional trips, making a total of some 10 to 12 trips, that their interest was centered on the jewelry store or the airline operators. That after making the total number of trips, they then went across the street. And there again, the 3 men came together, at which time they were having a conversation, at which time the officer had concluded that they were casing the establishment for a stick-up. Under these circumstances, I say to the court that the taking into consideration that an officer who is by himself, taking into consideration the number of persons involved.
But didn't your own court say they still did not have probable cause for arrest? As of this point, we're now at.
The trial court indicated that at this point that there was not probable cause for arrest. The appellate court did indicate that there was probable cause for arrest after the frisk took place.
No, I mean, we haven't frisked him yet.
That is correct.
So he didn't have probable cause to arrest when he approached.
I would agree with this.
And he didn't get probable cause till he put his hand on the butt of the gun.
He didn't get probable cause to arrest
him until he put his hand on the butt of the gun in his inside coat pocket.
No, sir.
Is that right?
No, sir.
Well, when did he get probable cause for arrest?
He received probable cause for arrest when he turned Terry around and ran his hands over the outside of his clothing and feeling a gun in the upper left breast pocket and indicating emphatically at that time that what I felt was a gun, a weapon.
Well, he didn't have it, as counsel for petitioner says, he didn't have it when he laid hands on him and turned him around.
I would agree with, he did not have probable cause to arrest.
Right.
I would agree that he would have probable cause to frisk or to lay hands on him at this point.
Why?
Because of the nature of the circumstances and protection of his own life.
He didn't see it go. He didn't say he saw a gun bulging or anything like that.
No, he did not say that he saw a gun bulging. He indicated that they were casing a joint for robbery, which implies a crime of violence, which implies that they have a gun. That coupled with the fact that after he made an identification of himself when approaching these men and indicated to them that he was a police officer, that the response which they gave was in the manner of evading the question which he had put to them under these circumstances. I think that...
What was the colloquy? What was the colloquy at that moment?
The question which was put to them by the officers, what are your names? As to this, there was a mumbled, incoherent response made in reply to that particular question. And this, of course, coupled with his observations and conclusions which he had made previously, there was probable cause for this officer to further investigate for weapons under these circumstances to determine and to protect his own life here. Now, it is my contention.
Mr. Payne, if we're going to use, you have said repeatedly now, I understand it, probable cause, are you saying something like this, that While there may not have been probable cause to arrest in the sense of taking him to the police station and booking him for some crime, at least in these circumstances, there was probable cause to arrest in the sense of asking them questions. Who are you and what are you doing here? Is that what you're saying?
I hesitate in the use of the
Well, you keep
term
saying
arrest.
probable cause in the circumstances, and I gathered what you must mean is that if to detain them is an arrest, that it was to be a detention only long enough to find out what they were doing,
That is
who they were
correct.
and what they were doing. Is that right?
That is correct.
And that then if the officer had probable cause to think they had weapons on them, in those circumstances, he was justified in frisking them for weapons. Is that it?
That is correct. And if I may put it in my own language, I am saying that there was probable cause for the officer to interfere with their freedom of action at this point.
Well, that's what I
That
say.
such interference with their freedom of action is not in a significant way at this time.
Well, that's what I understood to be your argument from the use of probable cause. Then what you're really doing is saying you don't have to change the labels. Still probable cause, and it's still an arrest, but an arrest for the purpose merely of asking a question, who are you and why are you here, is a different thing from an arrest for the purpose of taking a station house to book them for a crime, you know?
Under Ohio law, I could not agree with this concept because under Ohio law, the definition of arrest is by statute. And- statute. And it contemplates
Well, forgetting Ohio law for a moment, how about for the purposes of the Fourth Amendment?
for the purposes for the Fourth Amendment, it would be reasonable action on the part of this officer. And if
But I thought you agreed with Justice Black before that really reasonable action and probable cause are pretty much synonymous terms.
I do, Your Honor, and I think for
So we
purpose,
can stick to the jargon probable cause and
I agree.
make the distinction that way.
I think that the court can stick to the jargon of probable cause and make any distinction in the circumstances under this respect.
May I say that, as I see it, what you and the states are really standard arguing that by stopping them or to asking questions by an officer is not an arrest under the Fourth Amendment description of an arrest.
It is not an arrest under the
Seems to me that that's the real basis of your argument.
that
What
is
they're
the,
talking about is an arrest, complete arrest. You're saying it doesn't arrest him, ask him a question.
it does not arrest him to ask him a question.
And you're saying, I imagine you're saying also, it doesn't necessarily arrest him to touch him.
It does not arrest him to
Might
touch
be an
him.
assault, but not an arrest.
It might be an
Under the
assault,
constitutional meaning.
and it does not interfere with his freedom in a significant way.
You hadn't taken him into custody, you're saying.
That is correct,
As
Your Honor.
under an arrest.
That is absolutely correct.
Well, Mr. Payne, that's not quite the same thing you said to me. I don't understand that the same thing
May
you
I-
said to me. I thought you said to me earlier that there might be arrest for some purposes and arrest for other purposes, Fourth Amendment purposes. And then an arrest for the purpose of asking a chap his name, which follows from a detention.
Well,
Or what's he doing there? There might be probable cause for that sort of thing and without any violation of the Fourth Amendment. Even though there could not be in the same circumstances.
I did not.
Probable cause to take him to the station house in Brooklyn for a crime.
I did not mean to imply, because I'd indicated to the court that certainly arrest in Ohio is defined by statute. And I did indicate, I thought, to the court that the detention of his freedom here at that time is not an arrest in the sense that we understand it to be.
It's certainly not an
under-
arrest in the sense of taking him to the station house and booking him for a crime. But if he's detained, isn't it making an arrest?
No,
Well, Mr. Payne, couldn't you say that when he laid hands on him and swung him around, that petitioner's freedom of movement was arrested?
I would agree that his freedom of movement was arrested.
But that's not arrest.
I do not agree that his freedom of movement was arrested in a significant way.
Because he only turned him around. It didn't take long to turn him around?
No. I mean in the sense of the circumstances involved at that particular time.
In this particular case, he laid hands on him and swung him around. How many days later was Payne free to go? From that moment on, in this case.
If there had been no more, then
No, in this particular case, when did he next get out? When did Terry get his freedom?
sometime after he was convicted of the crime of carrying a concealed weapon.
So his freedom was arrested for quite a while.
Not on the basis of him swinging him around, but on the basis of the concealed weapon which he was carrying and the crime that he was committing in the presence of the officer at that time.
You don't deny he was arrested. You were arguing about what time and what conduct he carried before he was arrested.
That is correct. That is correct. The
When did the arrest take place?
The arrest.
Speaking in ordinary terms, now not little arrest or big arrest, but just speaking in ordinary terms, when was he arrested?
Speaking in ordinary terms, he was arrested after the officer felt the weapon and ordered them into the interior of the store. And it was not until that time, after he felt the weapon on the outside, he did insert his hand and feel the butt of the gun afterwards, and after taking them on the inside, and they were placed against the wall when the coat was pulled from his shoulders, and then the gun was taken from out of the pocket of Terry. He then went to the other petitioner and patted him on the outside of his clothing, and thereupon felt a weapon that he testified to. And it was after patting on the outside of his clothing that he inserted his hand in his pocket and removed the weapon from the second individual or person involved here. So the arrest took place the moment that he ordered them into the store itself. Their freedom of movement was interfered with significantly at that time, so that they could not go.
Let's use Fourth Amendment language then. When was the first seizure of the person?
The first seizure of the person. The first seizure of the person was at the time that he ordered them into the store.
You mean when he took Terry and swung him around, there was no seizure of the person?
I think there was a temporary detaining or interference with his
Well, he
person.
had his hands on him when he switched them around. Surely there was no seizure of the person.
All right? But here again, we're dealing in simply semantic words.
No, I'm asking, that word's in the Fourth Amendment, isn't it?
Agreed that it is, sir. There was a
What's the
touching.
difference in seizure and arrest?
The
You
difference
don't seize the man when you hit him. You don't seize him maybe when you grab him. I mean, you
in
may seize him because you seize something tangible. But that's not what you're talking about in the seizure of the Fourth Amendment, I thought. I thought it was an arrest, evidence of arrest.
it is arrest that I understand that we are discussing in this matter.
Well, an officer could very easily turn a man around without arresting him.
I agree with this, and this is the position that
Might not
I
be
take,
easy, depending on his style.
that he could very easily turn the man around, and some may term that as a seizure of the person himself. But I would not term it as a seizure of the person himself unless he has the intention of taking that person into custody, even though he may lay hands on him at that particular time.
Well, he undoubtedly did this when he ordered him to get into the store and turn his palm towards the wall and stand there. That's undoubtedly. At that point, there can be no doubt about an arrest.
I would agree with
Yes.
this. I think that the affirmance of the conviction of the petitioners on the law in the instant case is reasonable, is necessary, and is appropriate to secure the safety and the welfare and the best interest of the public of the state of Ohio, because we are asking here. And I am perhaps bound to indicate that the Court of Appeals has suggested in this particular case that we authorize the stopping under these circumstances where there are these surrounding circumstances for the protection of the officer's life and for the protection to the community that will exist if this is not permitted in this manner, in this way, depending upon the circumstances that exist at this time. The means that is selected as enunciated by our trial court and the Court of Appeals in this case have a direct, substantial relationship to the concept of the safety and the welfare sought to be attained in the affirmance of this particular case here. If we consider the comments of the trial judge at the time that he gave his opinion in connection with this matter, the trial judge made these remarks. I'm a great believer of the personal rights propounded by our Supreme Court, reiterated and reaffirmed, neglected over the years, and given to us under the Fourth Amendment and other amendments of the United States Constitution. Secondly, the trial court said, at the same time, a police officer cannot, as far as this court is concerned, and will not be permitted to stop and frisk an individual simply because he has a suspicion, a mere suspicion, unless there are reasonable circumstances justifying the frisk. 3, when the circumstances justify and there is reasonable suspicion, and for his own personal protection, he may frisk to determine if there are weapons for his personal safety. 4, the officer assigned in the area which he had been placed, doing the job he had been doing, and had reasonable cause to believe and to suspect that the defendants were conducting themselves suspiciously and some interrogation should be made of their action. 5, there was reasonable cause in this case for the officer to approach these individuals and pat them down. Here is a decided attempt on the part of the trial judge to equate and balance the rights of the individual with the rights of the public and the safety that is involved herein as it pertains to the officer in this particular case. What are the reasonable cause circumstances that existed in the minds of the officer at that particular time? 1, we have a police officer that was in his particular area on duty. And his duty is to maintain law and order. His duty is to prevent crime if he can so do. Secondly, he has 39 years of experience herein. 4th, the observations of the suspicious activity which he observed, which may be determined as pre-detention conduct. 5, he concludes from the observation and the conduct of these men that a crime of violence with the use of weapons is to probability may be committed under these circumstances. 6th, he decides to investigate and to interrogate, and the record indicates and shows that at this particular time, why did you go over to these men? I went over to them to ask them some questions. 8, when he asked their names, he received this mumbled, incoherent response, which further gave rise to the circumstances that he had concluded previously that a stick-up was possible here. At this point, taking into consideration the nature of the crime which he has concluded, a stick-up and the use of weapons as they are characteristically used in a stick-up, there is only one course of conduct then open to a prudent police officer, and that is to frisk or pat for weapons for the protection of his life. And this is why we considered in the interest of safety and the public welfare in the state of Ohio. 7, or not 7, but 10, there was the absence of assistance to this officer at this time in relation to the number of individuals involved here. There was 1 police officer and three men. The type of clothing also he considered at this particular time because they were wearing overcoats and the possibility that they may conceal weapons as they existed here. The sex of the subjects, I think that he had to take into consideration at this particular time that there were 3 agile young men that he was confronting, and he was by himself at this particular time. Under these circumstances that he was confronted with at this time, I believe that it is in the interest of public safety. I believe it is in the interest of the welfare of the community and society that he have the right, based on these probable cause circumstances, to frisk this man, to temporarily detain him, to ascertain that which he has observed, and to confiscate any weapons which he may find on his person at that particular time, and that they are admissible in the evidence of his trial subsequently thereto. I think that if, as the question was placed by one of the justices of the court, that after probable cause exists here in this particular case, I feel that the judgment in the case should be affirmed.
You may have 3 minutes to finish your
Thank you.
argument. Your time has expired.
Thank you very much, Mr. Chief Justice. We would just ask the court to consider that on the state of the record, if this police officer is acting upon the suspicion that he has that these 2 men are casing a place, that the stores where they're supposedly casing are located on Huron Avenue at 14th Street at the Apex. These men have gone down Euclid Avenue, where Huron Avenue cannot even be seen. They are standing in front of a store there that has not, on the state of this record, been cased at the time that they are approached and subjected to the arrest. We would ask this court to be mindful also of the fact that if this court does affirm this decision, it will in effect be affirming the decision rendered by our Court of Appeals in which they have established the fruit of the frisk doctrine for the state of Ohio. I would ask you to keep in mind that the state of Ohio's legislature has just considered a few months ago and rejected a stop and frisk bill similar to that of the state of New York. Lastly, we would ask you to consider that in accordance with decisions such as DeRay, where this court has said a search is either good or bad when it starts, and it does not change character thereafter. And that after the event justification does not relate back to justify the original initial unlawful search.
Can I ask you if this is not what you really asked us to hold? I'm not saying you shouldn't. You asked us to hold that I understand. No officer has a right to interrogate people that he did and expect and get an answer unless he already has in his possession or in his mind evidence sufficient to show probable cause that that person has committed a crime or is about to commit it.
Can't take it that far that I'm saying.
Well, how far would you take it?
I'm saying that where the police officer chooses, with reference to whatever his determination has been, to interrogate or to investigate further with respect to citizens lawfully on the street, that in order to exercise dominion or custody or control over that citizen and thereby deprive him of his rights under the Fourth Amendment, that he must have before approaching him that probable cause which this court has made reference to in its decisions.
Well, what about asking the question in respect to an answer?
I'm saying he has the right to approach him and ask his question.
Does he have a right to expect an answer and to do anything whatever if he doesn't get it?
I think that in the absence of this person having committed any crime of any sort, and where the approach is based upon suspicion alone, the person being subjected to the interrogation has the right to refuse to answer or to turn away.
What you're saying is, admit I thought it was, and I think now it still is,
Yes, Mr.
that a policeman does not have a right to ask a person a question on the street and get an answer, or to keep him, or do anything else except just ask him a question, unless he's in possession of sufficient facts to know that that man has to have probable cause to believe that that man has committed a crime or is about to commit a crime.
Mr. Justice, I'm sorry if I'm giving you the impression that the police officer cannot ask him a question.
I said can ask him a question, but cannot get an answer and do nothing about failing to get an answer.
He can arrest him if he chooses.
He can arrest him. But suppose he doesn't choose to arrest him.
Then
Suppose he wants to do something short of arresting him.
then I don't think he has that right.
Then the man can go on off, not answer questions, because the officer doesn't have at that time sufficient amount of evidence to make a case of probable cause of guilt of committing a crime.
That's precisely what I'm saying, because otherwise his
I
inviolate
wasn't
right of
trying to
privacy
get
would be
you to say
invaded.
something. I thought that was it.
Yes, sir.
Very well. So,
Thank you.
What's up, everybody? Sufficient facts. There's a link at the top of the chat. Anybody wants to come up and discuss this? I got personal opinions. And one is, it can't be a hunch. Can't be a gut feeling. It has to be facts. Period. What's the definition of facts? I mean, if it's facts, then that means he knows 100%, like he had to have physically seen a weapon. I believe in the case law, it also talks about they have to not only be armed, but armed and dangerous. Do you know how many people a day in America, every city, every state, are stopped by the police and Terry frisked, and they don't have nothing on them? I mean, in the last few years, I've witnessed, hundreds, if not thousands. Too many to count. I don't know. It's pretty crazy. Crazy, crazy, crazy. I like this case law. It's an important one to me. It's one that, through my videos, I have witnessed a lot. Sure, we don't always know what's going on. We usually don't always have all the evidence when we're just standing there watching, but sometimes we do. And so, yeah. Anybody else got an opinion on it? Anybody want to come up, talk about it? Plead the fifth. No detained without PC. I want a lawyer. What's up, Rich? Steak? Neil, thanks everybody for watching. Cop Block, Hot Springs. And just somebody having a gun on them is not enough. They have to be dangerous. We got somebody coming up.
Hey, Chuck,
What's
how
up?
you doing?
Good, how are you?
Okay. The Terry frisk is misused 95% of the time. They see a cell phone and assume it's a gun. They see a wallet, assume it's a gun. They put you in handcuffs for detention, for a detentive investigation, which causes nerve damage. I know because it's happened to me. And I don't like the Terry doctrine at all. It's overused, and they're not stopping them from doing it.
Well, I mean, I
My
think if it's
opinion.
followed properly, I kind of like it. I like the
Well,
fact that they're not allowed to come up and just stop you without, and you dig in your pockets.
but they do.
I know they
Especially here
do,
in
and I know they don't.
California.
That's a whole different story that that they don't
Yeah.
follow the law. I mean, that's a whole nother problem. And I agree with you 100% on that.
Yeah, they
But
do that here in California.
they do it everywhere. They do it everywhere.
Yeah, I've seen
Unfortunately.
that. I've seen that. It's just unfortunate that civil rights are not taught any longer. The Constitution is not taught any longer in schools, and people don't understand their rights. The Constitution is not taught any longer in schools.
Hi, Sheila.
And
What up, Chuck D?
What's going on? Will you mute your TV? I think it might be.
Yes.
I don't know.
Yep, I got you.
Perfect. Thank you. Go ahead.
Okay, I'm gonna take myself off of cam because I can't do it the delay.
It's all good.
Listen, I'm glad you pulled it up. I'm glad you did this evening because I've been I got hip to it from San Joaquin, Delete Laws. He had premiered Delete Laws, and I started, really getting into some of these caseloads, some of these Supreme Court cases that have really done a job on the law, period. You know what I mean? They have really stumped all over your human rights. Just by the stop and frisk or the Terry stop and all of that. Man, I say once that case was argued, whatever, somebody went in the room and said, yo, this is what we're going to use to lock people up, or this is what we're going to use to harass people. We're going to use Terry v. Ohio. It's still going to work, y'all. Everybody's suspicious. We're all scared for we all fear for
yeah,
our
but
lives.
suspicion's not enough. A hunch isn't enough. Gut
But they
feeling's not
use
enough.
it.
I know they do it, but I'm just saying legally they have to
Yeah.
have facts that you are armed and dangerous, not one or the other, both.
And Chuck, how many of y'all have been claimed armed and dangerous just by recording?
Oh, I know. Everybody.
Right? How many of y'all
Yep.
have been ID'd, just trying to ID you because you're suspicious activity?
Everybody.
Right? You know what I mean?
Yep. It's
That's true,
unfortunate,
and
but it's true.
And when you tell them, I don't need to ID unless I've committed a crime, you're uncooperative, you're labeled, and you're followed.
Oh, wait. Let's talk about the fishing. Y'all know when they go fishing?
Mm-hmm.
When do they go fishing, Chuck?
They don't stop fishing.
Exactly.
When they pull you over for a broken tail light, your tail light not broken, but then they want to search your car. They
Yep.
smell weed. They see a speck of an ash of some powder on the floor.
For me, it's been my license plate lately. That's what their go-to.
Yeah, you know what I mean? Like stupid stuff. And then why you got to step out the car because my license plate, my light is out. Why I got to step out the car? Why you fear for your life because my light is out?
That's right.
You know what I mean? Like I see this and people will argue me down saying you don't know what Terry v. Ohio means. And I say they do it every day. They still use Terry v. Ohio on folks every single day. The cop, I called the cop. I seen a man coming out of a man on one of the apartments buildings right next door to me. He was coming out the building. He was on the porch and he was slinging the mail all on the ground. So I said, yo, stop that. Why would you be littering at your apartment building? Well, he told me to shut up and mind my business. So I went to proceed to put my bike up on my porch and lock it. All of a sudden, I see dude come out the building. He pulled the alarm, putting his hood on, running out the building with a big backpack. So I said, oh, hell no. You robbing the joint. Call the cops, call the cops. So he hollering he got a gun. But I wasn't scared of him. I didn't think he had no gun. No, I didn't think he had a gun, Chuck. Let me tell y'all why. Because he ain't had no shirt on. He had a hoodie on. And he was only wearing one shoe. You sound like somebody with a gun?
Yeah.
It does?
No, I'm being sarcastic.
Oh, I was going to say. Because I had the little pipe, you know, the pipe that go for you to lock your bike up. I had that still in my hand, right? So when he said he had a gun, I said, I don't care if you got a gun. I will jab you with this damn pipe in your fat ass stomach. Excuse me. No pun intended to nobody.
It's all good.
But anyway, he got away. And when the cop came, I called the police. When they got there, I told him what happened. He was listening to what happened. And then he said, what's your name? So I told him my name because, just in case he need me to ID the guy or whatever. He said, what's your date of birth? Yo, wait, I'm going to show y'all the look. I gave him that look like, what you need that for? Why you need my date of birth? He said, I need it for the record, for my report. I said, no, you don't. I said, you need it to run me. I know it. Come on, man. Stop. so
have they ever taken that when you say stop to them? What? You want me to stop helping you? I've gotten that several times.
I've heard that.
Yeah. Yes, I want you to stop helping me into your jail cell. Leave me alone.
Or your bullcrap.
I know. They take in turn everything. I was assaulted and injured, and I require surgery to fix the injury from the assault. And the cop wouldn't report. He goes, well, it's they say, you say. Because I was injured by a security guard.
Oh yeah, they take their side over yours. It's always your fault, not the store person's fault, not the people. It's always your fault. You spent your money, but you're the bad person.
This was at a hospital. Yeah, I was going to a doctor's appointment at a hospital, and it's during the last year, so no one's allowed in the hospital, 1 or 2 people at a time. You can't sit in the lobby. You have to be escorted. And I'm handicapped, so I walk with a cane. And they go, watch out, she can hurt you. And I turned around and I said, are you insane? What's wrong with you? Don't be argumentative. People
don't have no public sympathy no more. They don't sympathize with people anymore.
A lot of people, when they see me, they're really nice. It's just security or the police or
is it allied security? It's always allied. It's always allied.
It's Blackstone.
No, okay.
That's out here in California, Blackstone.
Okay.
But I've even been attacked by a high schooler. He was with his girlfriend. He was about 17.
It's a damn
And he
kid.
was with his, he was with his girlfriend, and he wanted to get on the elevator at a shopping mall, and the elevator was packed, and it wasn't anyone's floor to get off on, and he wanted someone to get off, and he yanked me out, and I almost fell, and I was in tears. I turned around and I put my cane in his back and pushed, and he came after me. So
Wow.
it's like, I just told him, I says, yeah, go ahead, attack a 74-year-old woman, and
Wow.
tell your friends, tell your football team how strong you are.
Right.
But I couldn't believe he did that. It was like, wow. But I don't understand. Yeah, he had his football jacket on, and get out. Someone needs to get out. We want to get in. And it was like, wow. I said, well, I didn't say anything. I was standing next to the door when they opened, and there was a stroller behind me. Another couple, two other. I mean, the thing was packed.
No one spoke up for you?
No, they were afraid of him.
Sad.
He's a big guy. He was a big guy. But I guess I shamed him enough not to hit me anymore. So
he wouldn't have been teabagging the next morning. That's for damn sure.
That's true.
He wouldn't have been teabagging the next morning. That's for sure. I'd have gave him a good shove in them damn nuts. Okay, then I'd have called 911.
Well, I don't carry a phone with me.
Oh, you need to get some furry potato fire sauce.
I have that, and I put dye inside of it.
Okay, you need to use it.
So when it fires, it's going to stain their clothes and hurt them, sting them.
That big nigga would have went down. Excuse my expression, y'all. Yes, I used the N-word. That big nigga would have went down with my fire sauce. I'd have been spraying his ass and hitting him in his tea bags.
Yeah, I was just out shopping, and it was the funniest thing. I was out shopping. At that time, I was only 63. So this happened a long time ago. But it's like, wow, I can't. It happened at Horton Plaza, downtown San Diego. Of course, that mall is being revamped into apartments and what do they call it? Organic food stalls, things like that. So it's no longer an department stores.
Cop block. I'm sorry, cop block. That's what I say. Kick them in the tea bags, man. You know, they like tea bagging sometimes. Hurt them tea bags.
Yeah.
Chuck, you still there? I'm sorry to be talking about the tea bags.
No, you're fine. I've been laughing, but I guess I was muted. Sorry.
Well, wait. So I got the tea bags from Phil. Phil was live. You was there, Chuck.
Oh yeah.
Yeah.
When I was giving class, Chuck, you was there. Yeah. But Phil started me with the tea bag in the day. Listen, I love Wayman. I tell you, Chuck, I've been around for a long time, man. I've been watching y'all for a long time. You, Joe Cool, all of y'all, man. Rogue Nation. I've been watching y'all for a minute.
I know.
Over a year. I love watching you guys. I love being in your chat rooms too. Just, you know, I just have a hard time with people speaking. But every day when I tell Freedom that Flex today, every day I'm gonna be teaching.
There's Omaha. Get back up here.
Floyd.
He was trying to come up during the middle of it, and I don't think he realized there was another 45 minutes left. I usually don't talk during the, that broadcast till afterwards.
Floyd, come on up, man. I enjoyed your interview with Doc's Andre. That was a great interview, man.
Lady B, let me see your face real quick. Nobody else will see it, just me. You can just turn on your camera, then turn it back off. Okay, you're fine. If you don't want to show your face, just leave it off. It doesn't matter.
I like how y'all do that.
Oh, Chuck, I appreciate that, my friend.
There you go.
And my name is Lady Beju.
Okay.
And
Hi,